Seems to be the question test is testing the limits of the reach of section 200, section 15 of the Electoral Act, and whether it is constitutional, if it is to be understood in a manner subletting is wording. This section is not challenged before this court. It stands as law that was passed by Parliament. If its import is as I submit, that the state of non-compliance in the first part of the section is assumed, and in those circumstances the court is prohibited from setting aside an election if the election is in any event conducted in accordance with the principles of that part. And the mistake of non-compliance did not have an effect, but it did not affect the results. If the question is whether that provision is consistent with the Constitution, that is not before us, before the court today. The question, the good question that is before the court is whether the President could have done what he did on the effects of this case based on the recommendations of the Commission because of issues that arose during the elections, where it was established that some voters at specified polling stations may have been deprived of the right to vote, whether that action of the President of extending to allow for those voters to vote on the 29th and the 30th, if that is found to be unlawful, then what is the import of this section? What does section 115 say in those circumstances? Where the President announces the 29th and the 30th to be polling days. And this court says the President did not have the power to do so. What does section 115 say in those circumstances? That is the nearest question that is arising here.
What does it say?
In section 115, our respectful submission says that the court must still consider whether the mistake of non-compliance, or whether the election was in any that is still conducted in accordance with the principles despite the breach of the section, despite the breach of section 64, 1B, the regulation was in any way conducted in accordance with the principles in terms of part 5 of the Act. And if it appears to the court that indeed eligible voters were allowed or afforded the opportunity to vote, it was a transparent process. The party agents were allowed to observe the result of posted on the site, in the line. The court should not upset the election. There is a prohibition to do so. So that is the context within which the question arises. Of course, the Lordship, I submitted earlier that if the government extends the election, the mistake of non-compliance will certainly be established. Because the government is indeed in the extends the election, announces the dates of the election. My submission would be such an election cannot be found to be in compliance with the principles of section 6 of part 5 of the Act.
You will move on to the next point. So I have to make economic use of your allocated time.
Yes. I'll move on. Yes, referring to section 204 of the Act, the judgment that my learned friend for the person in the field is the Minister of Finance versus the Labour Commission and others. The second in paragraph 31 of our Act of Parliament. That is where fiction, in our respectful submission, the case article of fiction is referred to. Now, my respectful submission will be that for there to be established in the state of non-compliance such that it affects the results, affecting the results in the sense that the outcome of the election would perhaps be different. One is to pass through these two sections, section 204, to establish the mistake for non-compliance, and section 115 for the court to apply the testing they set out. And in accordance with the principle of subsidiarity, we submit that each section 204 or section 150 are constitutionally wanting. It is not incumbent on the applicants to ignore them, but to make a frontal challenge to these provisions. As we submitted earlier, the provisions or the legal principle in our respective submission are not set outside the scope of reach of section 115, because that is the very thing that the section should be developed cautiously, judiciously, pragmatically, if it is to spend a period of time within those the rules of practice to decide no more than what is absolutely necessary for the decision of a case. Now, in this case, our expected submission is that the facts are governed by these two sections, 204 and 115 of the Act. If then we submit that the applicants have not voted themselves within the preview of this section. And the normal position then is that the court should not accept the elections. In roll fund administration, cases cited paragraph 24 of our legislation, this court said that the prosecution must be the last and not the first resort in resolution of disputes that come before court. I say this was a starting statement at that point in time, because immediately one assumes or one accepts that the Constitution is the supreme law. In Atchison, was said in the Atchison 1991 Namibia report, at age 10, the Constitution of a nation is not simply a statute which mechanically defines the structures of government and the relations between the government and the governed. It is a mirror reflecting the national soul, the identification of the ideals and aspirations of the nation, the affirmation of the values of both its people, and the spirit of government. The spirit and tenor of the Constitution must therefore preside over and permeate the processes of judicial interpretation and judicial expression. Now, if coming from that perspective, that was articulated in 1991, it was a starting for some of us to hear that the Constitution must be the last resort. It is because in our respective submission, the principle of subsidiarity was not well understood. It is counterintuitive to think that the constitutional norm must be subsidiary or secondary to the statutory norm. And that is why instinctively one resorts to the principle of legality and asserts in a respectful submission that since it is a constitutional principle, non-compliant with it must, in this specific case also, result in a declaration of non-voting or setting aside of the elections. But if the principle is properly considered in its context, and one brings together the notion for the victim in artisan with the victim in road fund administration, what the principle seeks to achieve is rather simple. The Constitution still presides over all judicial thinking, on all judicial processes, but it is sitting, it's perched on top. The subsidiarity doctrine dictates in a respectful submission that whilst the Constitution remains the supreme law, and whilst it provides while its processes must permeate all judicial thinking, is normative positions that are created pursuant to the provisions of the Constitution, and in particular, the principle of separation of powers, conferring power on the legislature to make laws for this nation requires that this court and of all the courts to respect and uphold the will of the Parliament until
parliamentary supremacy or what?
Parliamentary
supremacy or what is it?
No, until that provision is challenged. It is not me saying so. It is this court that said that in Corona corrections. In Corona corrections, this court said that when prima facie represents the will of the three elected representatives of the people. Where the legislature has provided for specific procedure for the regulation of legal disputes, it is to that procedure that the public must have recourse in the first place and not the Constitution. If the procedure is found wanting, viewed from the prism of the Constitution, the appropriate thing to do is to skirt the applicable procedure, but to challenge it and make it set aside. That is the principle of subsidiarity, which guards against flourishing of parallel systems of law. That is Condona Corrections. Judgment of the side on page 17, paragraph 49 of the heads of argument. So it's not parliamentary supremacy, it's separation of powers.
I got the point. That's not objective.
It's
right.
Separation of powers. So also, same proposition in paragraph 48 of our heads of argument.
Now, so in relation to get to the facts of this case, when we go out of here, we must consider and review this affidavit and decide. Mr. Ndadi, I want to understand something in paragraph 93 of the affidavit of the law. We know the law. 5 of us here, I think you should assume we know the law. You tell us too much about the law. We want to get to the facts of this case. Paragraph 93 at page 283 of the affidavit of the Commission. I really want to understand what they are saying here. Some of the polling stations that were not affected by the shortage of ballot papers proceeded with counting upon closing as required under the Electoral Court, and others remained open. When they were open for what purpose?
There were two purposes.
Yes.
It was also set out in the affidavit. One purpose was to allow for exchange of ballot papers. Because once you close, you have to account for the unused ballot books. I think it was 36 form. And you have to account for it as the deciding officer. So if you have to transfer it to somebody else, that person will account for it. So we could not close if you had to provide our papers to those police stations that were in need. So that's one reason.
So while that process was going on, no counting took place, and as I understand it.
At those police stations that would provide those And then the other reason was that in terms of there were still people in the queue under at some of the polling stations. And those had to be attended for Electoral Section 93, Paragraph 3 of the Act. So you could not close them when you have people in the queue. Then some of them obviously had to wait to receive some of those ballots to continue the voting.
Two questions. One, what is said in paragraphs 93 and 94? Your understanding of the case. Are those allegations disputed?
No.
That's the one. Number two, I can understand in relation to the people in the queue. Those who were not in the queue, how did the ECN define that cohort of voters? How did they know who these people are?
There were specific complaints. That is also explained by who? There were complaints that were received, there were discussions with the deciding officers. So that was also set up in the affidavit. They received the ongoing discussions with the deciding officers on the 27th, even before the statement was made. And because of that, those discussions, eventually it was established that 36 physical locations served 29 teams.
So should I understand the ECN case to be, there are these people who are in the queue, and they have information that there are other people outside the queue who want to vote, who are not being accommodated. Is that the case?
No. The ECN case is clear. In respect of all the polling stations,
I'm talking about the 36.
About the 36.
Yeah.
Everybody who was in the queue was attended to before 9 o'clock. That is when those polling stations closed and started counting. So after 9 o'clock, or through the course of that night. Everyone.
But why not just end with those in the queue? How did they define this other group of voters? That's what I want to understand. That the people who were denied the right to vote. Or the ones who were in the queue, you cannot say they were denied the right to vote because they want to vote.
Yes.
How did they define this other cohort?
There were those places that were not reached. The polling places that were not reached. Because the teams were held up at other places. So if you did not get to the voter polling station, obviously those people could not vote. They have to also keep with that page 226.
Sorry?
Page 226.
Affidavit.
Of the affidavit of the commission. It says, attainment of communication of the commission is reliable information indicating starting the scope of the 36 commissioners, which are referred to below. Some of the voters were in a queue at 2100 hours on 27 November 2024. Could not cast their vote because of ballot papers had run out and could not be replenished in time before the voters left the queue. The ballot boxes were too full and could not accommodate additional ballot papers, causing voters to leave the queue. Furthermore, some mobile stations which are referred to in the Electoral Court by the polling teams on the 27th. And in respect of each of the other polling stations, whatever issues they will resolve, they will go on to allow them.
Before you move on to the next part of your submission, I'm trying to understand this. Much was said about the extension in relation to the proclamation and the issue to allow people to vote for 2 days. Have you heard? I read somewhere also in PCN's affidavit that there was no gap in terms of the dates in which people were allowed to vote, also allowed to run. This is taking you to that evidence there, and what your understanding of it is.
Yes, Your Worship, our technical worship here. But what as I've been explaining now, at some polling stations there were still people in the queue after 9 o'clock on the 27th. Those persons continued to vote past 12 o'clock in the early morning hours of the next day. Now, this actually brings also to that dichotomy between the polling day and the hours. One where the president has the power to make the decisions, and the other where the commission has the power, the commission of the state officers has the power to make the decisions. There seems to be some conflation, especially by the LPM, on these two different things. We have gone to the trouble of listing the references in the Act on in respect of the polling day and the hours. So the Act here was a decision to do the polling day. Polling day and polling hours. Polling hours are referred to in section 993, subsection 1. Subsection 1 of section 93. And your worship will see that the person who has the authority to that polling hours is either the commission or the officials. And it relates, it specifically indicates the hours of 7 o'clock to 2100 hours. But those hours are flexible, they can be changed by the officials. This was submitted by my editor and requested or not requested for submissions. But the polling day is something different. It is referred to in section 64. First in section 64, subsection 1. It says, if the general election right or by election is to take place in accordance with section 63, the president must have proclamation in the Gazette make known, subject to subsection 2 exist, the date determined by the president upon the proclamation of the commission upon which the poll must be taken. So that polling day does not have hours. So when the president deals with, makes that day known, it does not have to deal with hours, because the hours of poll are governed by section 93, which is something else. In section 93, subsection 1 reposes that power to determine the contingencies in the commission. So we cannot speak of polling day with respect to the hours when you consider the power of the president. The president only designates the day on the recommendation of the commission. And like any day, a day is 24 hours. So our submission is that when the proclamation was published at 2300 hours on the 28th of November 2024, it became effective immediately after the close of the 27th, that is the 2400 hours. So that is the input of section 12, I think section 12, subsection 2 of the interpretation proclamation, that is what it says. That is what it says. So the proclamation comes into effect on the first second of the 24th, of the 28th, sorry, of the 28th of November 2024, on the first second. I'm sure that is also what the action that was sent to the court, because it was also the extract that was sent to the court.
And the reinterpretation.
Yes.
Oh, I see.
Yes. So, but by that time, when the proclamation came into effect, there were still people in the voting. What should be like that to page 360 of the record? 316. Paragraph 194. 194. There we refer to the effect of the voting continuing up to the time when the proclamation became effective. So we say that there was no break as far as the day is concerned. That is now the powers of the president.
You have to speed it up.
Yes.
Rapid time action.
Yes, Your Lordship, may this end up. I have copied references to polling day, taking of the polls and the polling hours in the Act, just to show the judge the position of these different provisions in the Act and how they apply, so that there is no confusion between the polling day and the polling hours and the taking of the poll, that is the actual voting. I must just find the place and focus the phone. May I just interrupt those references? It will perhaps be useful for the court to have regard to that, because there is some conflation of these provisions in the Act. So they are used differentially. They are not the same thing.
messenger. Because they said, you don't feel sorry for us. What is we have?
So, the submission to the Lordship in regard to the powers of voting and the powers of the President, according to the regulation, the President certainly could repeat what is stated in Section 93, brackets 3, in brackets 1 of the Electoral Act. Because that is what is the indicated powers of voting. But this can change if we're still into Section 94 and into Section 93, brackets 3 of the Act. So what we are getting on that score is that, in fact, there was no risk because the polling day that was designated by the President ordinarily would end at 2400 hours. There is no stress. So the fact of the evidence on the voting continuing at the time the proclamation came into effect, that is proclamation number 34 came into effect, those are not disputed. So I'm hearing the court say it is unfair with the subsidiarity doctrine and that I will need to be labeled. I will move on. As far as the proclamation itself is concerned and the reading that is proposed on behalf of Dr. Nicola, that the proclamation require that voting should take place throughout the country. Our submission is rather simple. The proper reading of the proclamation indicates that polling stations were previously made known by the Commission, both in the Gazette and in the publication that is attached to the answering committee. Those polling stations were known. When the President was requested to extend the voting at specified polling stations, those were identified also. Those were also identified. They appeared in the press release that was made by the Commission, when the President was requested to extend the voting at those specific polling stations because of the problems that were encountered at those polling stations. But those polling stations are not any different, except that they are only 36. There are 36 of the polling stations previously identified in October by the Commission. So they are not new polling stations. And what the proclamation seeks to do is to isolate the 36 from the rest. That is what is referred to in the schedule. That is why the proclamation its own schedule. So from those ones that were previously identified, these are the ones where the polling should take place. That is what the proclamation says. It is not a difficult reading, because if that is not what the proclamation says, the court has to consider. While failing a singular schedule, which is not even attached to the very proclamation, but to the other proclamation that was previously made by the Commission. When the proclamation refers to the schedule and does not even identify the schedule that is attached to it, that is the reading that is proposed by the agent. So what we say is the schedule that GD 34 identifies is a schedule that is attached to it. With reference to the police stations that were previously made known. That is the simple meaning of GD 34. It does not talk about extending voting to the whole of the country. The facts that were available to the President, the facts that were available to the Commission only indicated that at the specified polling stations, those voters may have been disenfranchised. So, Your Lordship, the Deputy Chief Justice asked a question to my learned friend for the President. But why does the Commission basically assume if people have the right to vote and vote anywhere, why the 36? Why couldn't they go and vote anywhere else? There are two answers that are provided by the Commission in regard to that question. I will repeat the question. There are two answers that are provided by the Commission. The first relates to the identification of the 36 polling stations. Because it is only they, those 36, where the problems were such that voters may have been disenfranchised. Only the 36, those facts are not being met. But the Lordship will also recall that elections the Commission says if you can distribute or redistribute the ballots, the ballot books, now the unused ballot books, from where they were found to where they were needed throughout the country, it would defeat the very purpose of the extension. Because in that event, all the polling stations would then have account within a short period of time for all the unused ballot books. They have to account for them. And those ballot books will be taken from where they were and to be distributed to wherever they may be needed at any election. At that stage, when the decision is made to allow voting to continue at the 36 polling stations only, the Commission has not known at that stage, at the 36 polling stations, how many voters did not have an opportunity to vote because of variances that have been sufficient form. The Commission knows as a matter of fact that at all the other polling stations, whatever progress were resolved, all the voters that were allowed to vote. Now, how does it decide to redistribute these votes to all the polling stations? And in what time to allow for voting to be completed within the window of an electoral effect to just remaining the 5 days between the 40th and the 45th day from the nomination day. This should present great logistical difficulties to the Commission. It would be impossible to achieve that objective, but most importantly, it was not necessary. It was not necessary because those persons who wanted to vote attended the vote. For instance, we use page 289, page 289, 89, the answering application. Paragraphs 107, 108, 109, 110 on page 290.
If I was on that day in a Cuba, but I live in Greenville, and I was denied that opportunity, I must now go back to the Cuba from Greenville. I just want to understand that logic. I'll have to go back to a Cuba to go and vote there.
Yes, the assumption was that the persons would vote in the places they attended to. But let's look at the contract. There is not a single affidavit from any person, be it from the LT or from the IPC that says, I wanted to vote at a Cuba. There is no evidence whatsoever suggesting that there are people that wanted to vote, but otherwise were unable to vote due to the problem encountered at the 36 polling station. There is none.
My file says that it's none.
Yes, let's conclude with the submissions of course.
Yes.
If you watch this regard to the case about work by the IPC, there was a reliance placed on a version preferred by Ms. Almus. As it turned out, that person was unfruitful. I get it. The court said, but why is it even here? If the party puts up a version that is untruthful, I was personally present at the inspections. I personally conducted the inspection, that's what she said. And that person is completely untruthful. She was not. And it's demonstrated by the returns for the attendance sheets that were kept for persons who attended the inspections. And then reliance is placed, not only in the court below, but also here, on that version that is known to be untruthful. The Lordship is submit that conduct is going to need to be listened because of a dialogue cannot say the IPC. Also, as far as the LPA is concerned, there are a number of allegations relating to malafide of the president, the community. I'm not. I am submitting why costs should be awarded.
Yes, the cost for the entity represented.
Yes.
The large cost.
Yes.
One represented also this cost. It's not really something that fits this.
But your Lordship, my submission is if the were investigated before this court by making wild allegations, yes, wild allegations about bad faith. Of course, the President is alleged, the President acted under the jurisdiction of the Commission. That is a fact. So, those allegations are made regarding the Attorney General. But he's a member of SWAPO.
Let me try to put a different light on it, Mr. Ndadi. In layman's terms, the message that the court sends one of the cost order is to say, look, this case did not deserve to come to the court. That's essentially the message that we send, in layman's terms. Now, Mr. Heathcote, what eloquently set out the background to this thing about what is there in the public minds and whatever. Imagine if there was no court challenge. That's the perception the public lives with. Is it not better that a thing like this is litigated and the courts deliberate on it and give a judgment and it's clear in the public's mind? Either there was something wrong or there was nothing wrong. So I'm trying to put a different light to the bio-watch context. That could very well be a case why this sort of thing, remember what the focus has come to tell me about is whether or not the President's exercise of the extension power of law. And this court makes an authoritative statement to suggest such a thing should not have come to court. I'm afraid you are losing me, at least me, in the process.
No, I'm not suggesting that. I'm suggesting that you respect the court, in the application. Yes.
The chilling effect, I think what is being referred to by the Deputy Chief Justice, the chilling effect that the most order was sent to people who may extremely wrongly believe that there was something wrong and were trying to test whether they believe that there was something untoward in the conduct of elections must be tested in court.
All that I'm asking the court to do is to duplicate the unregulated assertions that are contained in the law. I am not one suggesting that the question whether the President has the power to extend for the serious or is not the one that is deserving of consideration by this court. That is not where I'm at. I am talking about the side allegations for which there was no evidence whatsoever. And that also indicates the Commission. But there is no suggestion of any such evidence being presented to the court. If the court says, perhaps such a thing should not be stated in an article if it is not going to be sustained. But I take the point that.
So you are concerned about the ventilation?
Yes. That incitement.
Yes.
That incitement. So that is what I'm drawing the court's attention to. So I'm asking the court to duplicate the bio-watch. There is an institutional challenge being raised here. Obviously, the reliance on the principle of legality. The Lordship, within the time that was given to me, will also be my submission.
Thank you. Is there another please take a vote here? you.
I felt like last born.
Your Lordship, I got directly to the issues that you addressed on behalf of the pardon me, Your Lordship, I do not really that well. I'm trying my best. First, we will address both the constitutional and statutory context, because we are of the view that that is very important in determining whether or not the presidential act on that day was valid or not. We will then, Your Lordship, go to the facts, common cause, largely common cause facts, in view of the manner in which the applicants treated the answering applicant, which is the replying applicant, so we then apply Laffontaine's test. I will then take the head after the fact, apply the law, having dealt with the constitutional and statutory context, apply the law to the facts to make out the case that, as we say in our end of arguments with respect, this is the weakest of all the electoral challenges in this court with respect that later rather have come before this court. And we'll demonstrate why we came out stating that this is the weakest electoral challenge ever to set before this court. Let's start with the constitutional context, Your Lordship. First is with respect a caution. In the Republican Party case in 2005, in April, Justice Nampa was part of the bench. The court, one of the findings of the court was that our law on election challenge has been developed carefully to achieve two main purposes. The first one, obviously, is to prove the judicial adjudication, to ensure that our electoral system does work, accountability is maintained, fairness is maintained, the fact that the election is free and fair is maintained. That's one. Why our law on election challenge has been carefully developed over the years. But there is another chief aim and purpose, which is to maintain the court's ability to resist against calls to invalidate elections on baseless allegations. Those sentiments with respect are in the RP versus TCN judgment. With that in mind, every time the court applies the law on the test, whether it is 115 test or whether Rule 7.1 of the rules of this court, which says that if you come to this court, your application must be supported by affidavit, which was the fact on which the relief sought is based. But it says, in addition, that affidavit must also disclose specifically and clearly the nature of grievance, and the reason, therefore, Chief Justice, that is specifically there because precision is required in matters of this kind, so that you know that the complainant of the applicant, the relief he or she wants is the one of recounting the announced outcome of the election, or is it to set aside the whole election process, starting with submission of names of candidates, etc., or what exactly is the relief being sought, Your Lordship? Hence, precision in matters of this kind is very important, not only on the issue of cause of action declared, but also on the remedy sought by the applicant. Hence, Your Lordship, one must guard against losers performing electoral rituals every year after 5 years after 5 years, there is a ritual in the form of a useless certification. When I say useless, without factual and legal basis coming to court. The rules of engagement are designed to keep out cases that do not deserve to come before this court. Let me then address the constitutional context, Your Lordship.
Before you move there, it's not because the word useless that you use there. It's not for a party.
I apologize.
This is not a language that we have in this court.
I realize that immediately when they can say it's the case that there is no factual and legal basis, but I do apologize to the Chief Justice. I address now the constitutional context, and this, Your Lordship, is very, very important to the ultimate determination whether or not the President, when he acted in terms of Section 44, 64, subsection 1B, had power or not. The first one is that under Chapter 3, 17.2, Article 17.2, gives every citizen who has reached the age of 18 the right to vote. Your Lordship, you have seen that we refer to the judgment of August versus ECN in South Africa, where the right, the fundamentals and the content of right to vote, particularly in a country like Namibia, where a certain corporation was denied the right to vote in the past, is so important. That is important. The right is given that if you are 18 years old, you have that right. Then the next section is that in Article 94, sub-article B, Your Lordship, the state did not just look at Article 17 and stand idle. It created a mechanism, structural, legislative, and executive mechanism for people to be able to exercise their right. That is to then establish an electoral commission, which has, in terms of the Constitution, a number of functions. I name few of them: supervise, control, management, direct, etc. The President doesn't have that direct power. Of course, he's a stakeholder in terms of certain power. But the underlying and the primary decision maker, manager, supervisor, controller on the ground is the ECN. And that our lawmakers have done well, placed it in the Constitution, then we have ECN. The second one, which is important, is Article 5 of the Namibian Constitution. That article is important, and one of councils who argued before me say that article obligates the legislature, the executive to protect rights. Not only the executive, it says the legislature, the executive, the judiciary, and where necessary or possible, also private institutions and individuals must all protect and uphold fundamental rights that include, of course, Article 17.2. And I'm saying this because when I make up the case as to why the President acted lawfully, this must be not a bad with respect to our mind. There is a right, then there are stakeholders involved that include a secondary stakeholder, the President, primary decision maker, the ECN, but there is constitutional obligation. So what I was saying, Your Lordship, Article 5 is not a dead letter. It's a live and obligatory provision so that when this court adjusts this matter, looking at the issue, it also has the right to advocate for justice, depending on how the issues are treated, to uphold and protect such rights.
it rains, we do have
what I was saying to the Lordship, we must take it and accept it from the common perspective that I will be referring to. One must assume, unless there were suggestions that, remember this is not some kind of a review against an executive decision of the President, unless there was some allegation that the President did not apply his mind and so forth on that basis, there was no attack on that basis. One must take it that the President was aware of the existence of Article 5, and as far as the fact placed before him concerning residents or voters in the 36 polling station. I then moved to the statutory context and we dealt with the constitutional context. The first one, the Lordship, and this is very important. When RDP versus ECN was decided on the basis of the 1992 Electoral Act, it did not have a special provision like Section 1, Subsection 2 of the 2014 Act. That is a progressive introduction brought about by Parliament, Your Lordship. You see that section in mandatory terms asks and enjoins anyone, and this includes of course executive and ECN, the President, and on the other part we interpret also the court. It says in the application of the Act and interpretation of the Act, regard must be given to the fundamental bill of voters' right in Schedule 2. Schedule 2 is there, but not in the interest of time, Your Lordship. One of the content of Schedule 2 is to embrace, promote, and franchise. In other words, create an opportunity that, as far as possible, make it easy for people to vote. Don't act in a manner that disenfranchise anyone, Your Lordship. I will of course address the issue of why was it necessary for the President only to apply the extension to the 36 polling station on the fact. That, Your Lordship, is in addition when the court applied the law then in 2018, this provision didn't exist. And of course somebody may say, but just really stating what ought to have been the case. But of course it has been given an statutory emphasis that is obligatory on the President the day he was considering whether or not he must act on the recommendation of the Commission. He will of course have to, in application of his power under Section 64, act in a manner that conforms to the obligations under that section. Then the next one, Your Lordship, is then Section 64. And I invite the court to go to that section because much has not been addressed by the applicant's counsel about the scheme and structure of the section, Your Lordship. With respect, before I go to that section, Your Lordship, I was thinking when the court was posing questions to my colleague to find a relevant case that is important in the context. And I found the case, Your Lordship, for Your Lordship, not in our heads of argument. The case called Minister of Water and Sanitation versus St. Paul Caesar, not Caesar. SIZA. Water PTY Limited, 2023, Volume 1, SA, Page 1, South African Constitutional Court, Paragraph 8A to 8.9. And may I read out this important paragraph before we deal with Section 64, subsection 1B. It says, 8.8, starting with 8.8, Your Lordship. In our law, it is common to have administrative action comprising two decisions taken sequentially by different functionaries like ECN and President. If this kind of administrative action occurs, each decision is subject to scrutiny to determine its validity. If the first decision was properly taken, it cannot be vitiated by irregularities which occurred when the second decision was taken. Then, paragraphs 89, Your Lordship, in the interest of time, Your Lordship will read. Now, if one goes to section 64, remember, Your Lordship, when I took the court to the constitutional and statutory context, I deliberately used the term like the ECN is the primary manager, primary controller, primary supervisor of the election. And the president has some executive powers as a stakeholder. Of course, I'm not saying his decision are not decisions. They are executive decisions, but to complete the process, Your Lordship. Section 64 says, if a general election or by-election is to take place in accordance with Section 63, the president must, and I highlight the word must, by proclamation in the Gazette, make now, in other words, announce, be subject to subsection 2 and 6, the date determined by the president. It doesn't primarily determine. It is upon recommendation by the Commission, upon which a poll must take place in the election. And Your Lordship, you will then see that 64 subsection 3B is that day must be, Your Lordship, not less than 40 days and not more than 45 days on the count, Your Lordship, the submission of names of presidential candidates on the 16th and 17th of October. We know now 27 to 30 fall within that period, Your Lordship. Now, there are jurisdictional facts for the president to act in this section. Jurisdictional facts. One of them is not a mere objective fact that must be there. It's an objective because there must be a recommendation by ECN. But this is kind of a jurisdictional fact that come in the form of a decision deliberated upon and decided upon by ECN. The fact speaks about it, Your Lordship, as the chairperson of the ECN spoke, how they consulted, how they had a meeting and decided, as the Commission, Your Lordship, they decided to make specific recommendation to the President. So, and then the President, obviously, then there comes recommendation pertaining to 36 polling stations. The next issue is your, of course, 64 subsection 3 requires that those days for determination must be not less than 40 and not less than 45, not more than 45, Your Lordship. And remember that in 63 days, another requirement, Your Lordship, not more than 3 months and so forth. Nothing of those is an issue in this matter, Your Lordship. As we understand the case for the applicants, apparently, the applicant, it was open for the applicant to attack the apex decision of the President on this basis simply to say the President doesn't have power. That is essentially, Your Lordship, when you look at the judgment of the Electoral Court, when we argue whether the issues that are raised in the Electoral Court are the same, we were meant to understand by the applicants that the issue in this court will be a serious issue in relation to the power of the President, Your Lordship. That complicates their matter with greatest respect, as I demonstrate. First of all, the President, Your Lordship, it's a fact there was a decision properly taken and not. In that decision, Your Lordship, I will submit that that decision is in accordance with Section 4, Your Lordship. Section 4, subsection 2020. Yes. It says, Your Lordship, without derogating from the generality of subsection 1, obviously one is the general one that they have independent power to manage, control, and so forth. So the Commission has fair powers and functions to and O exercise on
Section 4, the Electoral Act.
Yes.
420.
Yes. Am I?
So you are looking first.
Subsection 2.
2.
Is that not me?
Yes.
Yes.
Yeah.
I'm reading from Your Lordship.
As well.
May I proceed?
The due proceedings.
Exercise and perform any other power after the primary powers in subsection 1, Your Lordship, and functions conferred and imposed upon it by an act, this act, or any other law, which are necessary or expedient for purposes of achieving the object of this act or any other law. Now, the power to recommend a date is found in section 6, 4, subsection 1. That additional power. One of the powers of the Commission is to place a recommendation before the President in relation to a poll day. The only limitation is that it must not be less than 40 days and not more than 45 days. So that power, when it says exercise and perform any other power and function conferred and imposed upon it by or under this act, that could considerably and perfectly and appropriately be one of the powers because, Your Lordship, unless their decision, their substantive decision to recommend is attacked on the basis, Your Lordship, assuming there was a review and say, look, your decision was irrational, or you don't have the power, a lawful power to make a recommendation in the circumstances. If Your Lordship accepts that once the ECN as a primary manager, controller, and supervisor bring certain facts to the President, which are not disputed like in this matter, and those facts appear to favor furtherance of the right rather than restricting the right, then Your Lordship, facilitating an opportunity to vote is in accordance with the Act, is in accordance with the Constitution, and most importantly, is in accordance with the Bill of Rights of Voters under Schedule 2, Your Lordship. So now, therefore, if you accept with greatest respect that the Electoral Commission acting bona fide and without a bad reason in law or in fact, then the President was under obligation to act, Your Lordship. For his action will be to promote and achieve the object of the Act and the Constitution is actually, which is to open up and facilitate that people vote, Your Lordship. Now, Justice, that was a Justice in one of the matters that I had recently. You, in a nice way, I would say, we want to believe that it is dangerous for the court to find itself deciding a litany of issues. You refer to a particular principle, but for now I forgot the principle that you can end up just deciding issues which are not the issue identified in pleading. Focus on what is pleaded. Now, as I understand the case, Your Lordship, of the applicant, if you go to the text, at page 15 of our head of argument, page 25, we list them. One was before the President and not contradicted by Dr. Itu, as well as Mr. Swati. That includes, Your Lordship, and I go one by one. If the court go to page 282 of the record, Your Lordship,
Mr. Martin, I would say that the applicants had proved that the extension was done with the purpose of favoring the swap in those areas.
I know, there is no.
This decision would have been wrong under the circumstances.
I'm saying the fact put up by the President and the ECM and the election and choice of the applicant is not disputed. Once you accept those facts on the Glasgow Evans test, those facts, Your Lordship, unless there was an attack on the basis of lack of rationality or on the basis that the President acted unreasonably, those facts form a justifiable factual material for the decision of the President. But I will come to the issue of slaughter, Your Lordship, being further. There is no fact proving such serious allegations, Your Lordship. May I go to the record where I want to do it? Page 282, Your Lordship. Paragraph 91 to start. First of all, 89 to 91, the issue of these seriously malign machines is addressed, the tablets, so-called tablets. But in 91, the chairperson of the ECN put up the version in relation to what has happened and why it was only necessary to put up, to extend the respect of 36 polling stations. That version under paragraph 91, Your Lordship, for your note, is responded to by Dr. Itu at page 562. No, rather, for with greatest respect, it's you have to sweat around to look at this affidavit because there is nothing. In fact, it was not addressed. Remember, Your Lordship, the way Dr. Itu chooses to answer is to simply write an essay and doesn't specifically engage this particular allegation. There is no difference to that paragraph or any other paragraph of the Lordship. This affidavit is at page 564 to 580. Your Lordship, and this is serious. Both the President and the ECN chairperson, and in addition to engaged ever allegations. Not a single one has been dealt head-on by Dr. Itu, including this allegation. So, Your Lordship, in the absence of an attack by way of a review on the rationality of the President to only extend the respect of those polling stations on the basis of the version that the problem that existed at other pollings, 247 polling stations, remember your lordship that there were over 4,000 polling stations. Let me make this clear so that also the public also knows. There were over 4,000, and it's on the affidavit, 4,699. Yeah, exactly. Where there were alarms raised on the possibility of ballot papers running out, there are 247. And ECN said, we managed to fix that problem, and everybody at those 247 polling stations who was in the queue by 9 o'clock was able to vote for the vote. So in fact, they used the word restored. We restored all those polling stations. And the fact says, unfortunately, it's all over. The 36 polling stations, the program remained. 36. On that basis, your lordship, when you apply Plascom evidence, you can take it. And once you have that version, it's not attack that it's irrational or on the basis of discrimination or whatever. So one must accept it. If the president has power, based on the facts given to him, he could act in that way. Because there is another fact that is not disputed, and it's this, your lordship. The ECN says, remember under section 105 and 107, if your station is done, your polling station is done out of the 4,000 on that evening, they were saying there were no people in the queue by 21, and 21 comes. You are under obligation to start counting. And that version is there. Some polling stations started because there were no people in the queue. Those who finished processing in accordance with the law started voting. Counting is not started counting. I don't want to go in a debate whether it was justifiable rational for the president, but the good reason is on the paper to the fact that assuming the president then say they won't count. In other words, ignoring the version of the ECN that other polling stations were sorted out and everybody who had to vote voted. If the president ignored this version, then and on the 28th extend for the 29th and the 30th, then the outcome would have been even those stations that had in the meantime started counting, posting, and doing those packets for purposes of retaining officers to do the retain in terms of section 108 subsection 2. You would have then have them voting on top of announced results at those polling stations. So, but we don't need to go there, your lordship, because the president is not attacked on the basis of rationality or unreasonableness and so forth, or lack of application of mind. The president is attacked apparently he does not have power to extend, your lordship. Now, to then move and your lordship to also give the court another page, LPM made with respect. LPM responded. ECN in relation to LPM made the allegations at page 792 of the record. 792. Particularly paragraph 153 onwards to 7. It starts there from paragraph 153. The answer by LPM framework is at page 984. There is nothing at page 984, your lordship. In other words, to discard the facts and the explanation why it was done that way, your lordship. Now, I make submissions, then to demonstrate, given those facts, given the constitutional context, given the statutory context, Your Lordship, the President can easily, without offending legality, act, say the following. One must be careful. The power to extend are executive. The power to determine the date, Parliament allocated it to the President. But the President doesn't just act. He has given certain jurisdictional facts that must exist in the recommendation and so forth. And there are some restrictions and period-wise and so forth. Now, when this court, with respect, goes and considers this matter, may I give certain example to demonstrate to court that one must not make executive decisions a difficult undertaking for no good reasons. I say, remember the same power can be used in respect of a by-election or not. By-election, the section says that. For wisdom, if in Namibia Island, I know it's in Cape West, or in Zambezi, assuming the council, there is a by-election because the regional council and the Cape West resides. The facts on the ground is that for you to go there, particularly during the rainy season, you need some kind of canoe or vessel or whatever. Exactly. To go to Italia Island, where there will be voters. The President, in accordance with the proclamation, has made a date on recommendation. Unbeknown to the President, of course, not having supernatural power, that day, other villages, not on Imperial Islands, they vote effortlessly without any problems and so forth. Then there is problem with flood and so forth on that village. It is on that island. The President is given the same situation. Is given facts by the ECA. The presiding officer, who is there, would have in any way have the power in terms of 94 subsection 5 to say, to stop everything, it's raining, and we can start on another day. He would have been able to do that. But because, of course, of the importance of the matter, that there must be a public holiday so that people, the employers, do not give problems to the employee. The ECN, after getting a report from the presiding officer, decides whether to approach the President to say, maybe the next day, and so forth. Your Lordship, the law is not about nice principles and so forth. That's why Your Lordship, you can see people moving around. It's for the court to be not divorced from the reality outside of this court. Why you can see people moving around when one makes decision? Is because these are things that can happen in the watch every day. How on earth, with greatest respect, can my colleagues argue that in those circumstances, on those principles, the President does not offend the requirement of the recommendation, does not offend the 40-45 days requirement? The President is opening the door for a number of voters. And as it turned out, 9,000 Namibians at those polling stations were able to vote, Your Lordship. So the example with greatest respect is led by Justice Thomas, Deputy Chief Justice, the Governor. I don't want to add a matter which is not the one pleaded before, but I have this authority to say. Of course, a governor cannot act because in the first place, there mustn't be a recommendation from ECN. In the first place, the example given Your Lordship is that it would have been somebody acting in a position where he's not in a better position than somebody in the street coming up with a piece of paper and saying, I declare the election to be on this day. This matter is simply on the facts of this there is a recommendation. There is a huge problem. The other part of the problem is fixed. And these people must be given an opportunity to vote. Who is complaining about it and why? Remember, Your Lordship, assuming there were 2 days before the election and the President amended took 1 day off, like in the circumstances, just before you plan your things that I will go to South Africa to come back from Cape Town, knowing that there are 2 days. All of a sudden, the President takes off 1 day and leaving you out. Of course, in those circumstances, the applicant would be able to demonstrate that there was a disenfranchisement of the voters in the Lordship. Not in this matter. I therefore submit strongly to Your Lordship, our heads of arguments are there. We can refer to case law, demonstrating how it's not easy to deny that the President who is using executive power in a serious situation to address it in a manner of a Minister of Works and Transport deciding whether or not trucks must go through this road or that road. It's a serious fundamental matter to the right that a section of this country had long been denied that right. With that history in mind, we will always do everything to open up and allow everybody to vote. I conclude, Your Lordship, with these small submissions on the LPM notice of motion, Your Lordship. With greatest respect, I think that with respect, there must be discipline in reading the cases. The notice of motion with respect is convoluted. We as, first of all, I have decided to leave out whether they must join or not. But there is a problem, Your Lordship, because LPM did not commit itself to whether it finds the court granted the right to be an applicant. It must cease to be a respondent. It actually says in the papers that we will both be the applicant and respondent. It's there in the affidavit. Now, this gives us a problem on the facts as far as adjudging facts against us, Your Lordship, on trust on evidence. Whether they must benefit as applicants or respondents, Your Lordship. But that is not the bigger problem. The bigger problem is they are also attacking the decisions of the ECN. Your Lordship, go to page 588. Your Lordship, in the interest of time, the colleague has already dealt with other relief. I'm more interested, Your Lordship, at page 589.
Yes.
Your Lordship, if you look at the Act, section 1684, 168E, one of the Act, dealing with the powers and functions of the Electoral Court. Yes. That section says that court has a power, amongst others, to review any decision or processes of the ECN. Not President, but ECN, Your Lordship. So in other words, it doesn't even say in relation to the National Assembly, it says on any electoral issue. That's what the section is saying. Furthermore, in the rules of the Electoral Court crafted by Judge President, Rule 13, I think it's 13.4, gives a time period within which a review of any particular decision of being reviewed should be brought, which is 14 days from the time you came to know of the decision. Now, the first complaint and grievance on our part is that, Your Lordship, you look at the judgment of the High Court when we were told we must stay. We were told on this issue, when we come to this court, there is but one issue raised by the application in relation to the proclamation. That's what we were told. Now, if you look at 5.1, that resolution, whether it is being attacked on the basis of legality or other underlying reasons in the administrative law realm, it doesn't really matter. It's actually something that qualifies as a decision to be reviewed on any electoral issues by the Electoral Court. And it says nothing. If you look at that, why it may be in a journey to attack the proclamation, it's not attacking the proclamation necessarily, Your Lordship. Then, again, 5.2 and 5.3. Your Lordship, then, you also then look at the heads of argument, both of IPC and LPM, with the greatest respect. They conflate what they are attacking with implementation, because particularly IPC heads of argument, and we quoted in our heads of arguments where they say, the proclamation was very clear. It applies to the rule of the country, but the conduct of the ECL denied people of other polling stations the right to vote because they misapplied. Your Lordship, that is exactly, and we quoted portions of the heads of argument. But that act is post-publication of the proclamation. If the ECL, assuming it's true, that we are saying that the proclamation factually and legally applied to the whole country, that conduct is a specific conduct that could be attacked, prone to attack in any review proceeding and say, you misconstrued the proclamation on this basis. The exclusion of voters was a disenfranchisement of voters. On that basis, we want the election, and I'm saying it very carefully, knowing that you can't just take a legal hammer and hammer down everything, including combination. So that is an interpretation. There is a conflation and a confusion, a bigger one, Your Lordship, as far as the submission of this fact is concerned. Let me just look at my notes. I'm not too sure how far I got with it.
Take your time to get your notes.
Another issue, Your Lordship, just finding, Your Lordship, you may be aware, if need I can provide a judgment. There is a judgment of in Botswana of the Court of Appeal. It's called Law Society of Botswana. There's the President of Botswana and others. It's reported as 2018 Volume 1 Botswana Law Report 478. Your Lordship, that issue, one of the justices that come to read this judgment pertaining to section 96, sub-article 2 of the Botswana Constitution pertaining to Judicial Service Commission recommending the name of a judge to the President. And the President Masisi refused the recommendation. And there is a good debate which may be useful, Your Lordship. I'm not saying it's not in balance, which may be useful in interrogating my submissions in respect of the fact that, look, there are actually two decisions that need to be made in section 64, subsection 1b The manager of the election goes on the ground and identify a problem, make a recommendation required to law, and the president, the law says, must then determine the date. The president doesn't generate the date at all. The determination referred to there is upon recommendation of the commission. So in other words, it may even, your lordship, be argued, and I don't want to go in that debate. I'm simply saying that judgment may be useful, in fact, to the effect that it's doubtful if the president could refuse those recommendations. Because for what reason? If the incident comes to him and says, look, we have a situation to go to a village in Opua yesterday. Our vehicles have to cross a bridge, and because of flood, that bridge fell and we could not take ballot papers. We need to extend the respect of those people in that area. The president, if one of the recommendation comes to him, in good faith, for purposes of the act, cannot and should not refuse your lordship. The rest of your lordship in our heads of arguments, and none of the arguments remain in our heads of arguments, your lordship. We are not abandoning them, your lordship, in the interest of time. Yes, your lordship.
So to get the page number of the correspondent case.
It's your lordship, and 478, and I will ask my junior to produce to separate the judgment to court tomorrow morning, your lordship. My colleagues are just referring me that it may even be considered for analogy, Shanika versus the Minister of Justice versus the Magistrate Commission, Justice Maina Watata judgment in lordship. In regard to Swapo, your lordship, with greatest respect, we must not become a country who grow as a democratic country whose citizens have come to believe and to be taught that democracy and fundamental rights means that you can, as you wish, make disparaging remarks and say anything with no regard to those who make constitutional and statutory powers and those who are about and around you. So in other words, your lordship, Justice, Deputy Chief Justice, you remember in the ECL versus LDP 2013 Volume 2, Namibia Law Report, you refer to the case of Gates versus Gates. I think it's a 1930-something case which says that the more you make serious allegations with serious consequences to people in the community, you must have stronger evidence, your lordship. The same is stated in the matter of Zuma, Director of Public Prosecution versus Zuma, 2009, your lordship, Volume 2, South African Law Report, page 477. So, in other words, on what basis, when you tell the nation as a leader of the opposition party and accuse the ECL and the president that without any facts, put up your lordship and say, look, it's being done to favor swap. Even if it is correct, your lordship, I didn't find any evidence in the papers. Even if it is correct in the past, swap has failed, there is one. But you were given an opportunity to campaign by ECL. Why on earth do you make allegations of mother freedom for purposes of favoring somebody in a dishonest manner publicly in court proceedings, your lordship? We have to deal with these allegations, your lordship. This also goes as far as the affidavit by Mr. Itur. And we will ask that Dr. Itur, your lordship. Dr. Itur aggravates the issue of the National General Secretary of the State. Remember, your lordship, Congo, of the SWAPO party, and say, no, I was one of the people. She did not actually say it. She was not part of the inspection. If you look, Your Lordship, and I invite Your Lordship to look at the confirmatory affidavit of the General Secretary, actually says, I attended the inspection at the offices of ECN. Posting available, direct available. That is Your Lordship at page 63. 63. Paragraph 3, she says, pursuant to the order of the Electoral Court, dated 13 November 2024, I attended the inspection of the material at the head office of ECN and then compiled the report. Look at the answer of Dr. Itura in the reply, Your Lordship, without a confirmatory affidavit. We quoted it in our heads of argument in the last day to say that Dr. Itura had aggravated this conduct, this conduct that should not be in litigation. At paragraph 65, we quoted what Dr. Itura says. He said, although Ms. Akamus was not physically present, remember she said in her report and other affidavit that she attended the inspection at ECN. Then Dr. Itura, with respect, saying that for the first time, somebody said, although she was not physically present during the inspection, there can be no doubt that she was present virtually. Your Lordship, this is not a game. An election can be set aside. What if we did not come to court? Remember, Your Lordship, even in the context of 115, Your Lordship, you are under obligation with respect to decide an electoral matter, even without the respondent. So in other words, the prohibition in 115 still apply. And look at the papers, Your Lordship. We therefore, Your Lordship, seek cost against the two applicants and ask that the application so that, in fact, worse than other applications that said before this court, Your Lordship, and those are submissions. Thank you very much.
Thank you. Thank you. So, after that short detour, we're back to yes. I'm saying after that short detour, we just made a short detour, now we're back.
Yeah. Good. We'll take three propositions from the class, two one small. Now, this is very hard to concentrate here. First is an answer to Mr. Somerset's question about swap allegation. And we don't have any issue as an LPM whether or not the extended voting was to accommodate swap. We neutral. We don't say we read the evidence that doesn't go to it from our perspective. So we do not say that the President and the Commission extended the voting to certain stations in order to accommodate swap. At the same time, we don't say that they didn't. There's another question, and I think that you'll, as you have asked me to respond to reply. There's another question that I also was invited to respond to reply. I think it had to do with counting on the various days. I can't remember exactly how the question.
Well, I'm told that you raise your voice a bit.
It was very obvious.
Maybe the microphone is far from you.
I think that's the most unusual request I've ever had, and I'm usually told to lower my voice.
It doesn't come from me. That's a disclaimer.
Let me turn to why I meant to submit that what I've been listening to for the last 4 hours, and then 5 hours, causes to explode, not explode, sorry, implode. There's a difference. Explosion, boom. Implosion, boom. The defense collapses on their own argument. And I want to turn to two aspects to generate that argument. The first is this. It seems, and I say it seems, that it's accepted by at least the President and the Commission that were any of the 36 polling stations set out as a sort of schedule, Proclamation 34, not in Government Notice 305, they should lose. But they both made an affirmative submission, the President and the Commission, that all 36 were contained in the original Government Notice. The Court will recall that. Now those 36, the Court will find on pages 41 and 42, and they are divided into 4 regions. The original large number of polling stations start on page 5, and they are part of 3 schedules. The first schedule is the regular polling stations. The second schedule are those polling stations on page 36 which are outside of the limit. That's schedule 2. And then schedule 3 on page 38 are polling stations for persons who are members of the police force, defense force, and correctional services, and persons of the seekers. Now, I have to take somebody's word. I've done a check myself to a certain extent. I'm going to complete the check. But Mr. Sami, my secretary, tells me that of the 36 polling stations that are set up on pages 41 and 42, 25 do not appear in the schedules of the original government. Only 11 do.